Well, I'm not the one who takes that on. That's the job of the Attorney General. And I do not know, he has not informed me what his plans are for that, but I will say that, as you know, that bill was passed because there are people who work with those crisis pregnancy centers that misinform people. And it's under those circumstances where people are lying, misinforming, in which that law takes effect and people can sue if they're misinformed and given bad information.
That's Governor J.B. Pritzker yesterday being asked about whether or not the state's going to appeal a preliminary injunction against a state law he signed that allows the Attorney General's office to go after crisis pregnancy centers if they don't, say, for instance, offer up abortion as a service. And they could be charged with deceptive practices and possibly shut down after hefty fines. So what is the latest on this status? Well, we reached out to the Attorney General's office, and they did not respond to whether or not they're going to appeal. We'll take a look at the docket in this case because a group of pregnancy centers sued the state after it was signed in July, and then there was a preliminary injunction put into place. But yesterday, if you missed it, we did talk with Mark Glennon. He's the founder of WirePoints, and he's been focusing on the First Amendment and the importance of understanding how state law may be going against First Amendment rights. So here is Mark Glennon yesterday in a conversation we had with him discussing what exactly is going on with this particular law and how it's impacting Illinoisans' First Amendment rights.
Greg, it's an onslaught. This is the free assault on free speech, in my view, is a direct threat to democracy. It couldn't be simpler. If you don't have free speech, you don't have the First Amendment. You don't have democracy. This is at the federal and state level. Unfortunately, Illinois has been part of it. For example, the bill passed and signed into law recently that restricts the activities of pro-life family counseling centers passed into law was just a flagrant violation of free speech. Fortunately, the federal courts still recognize the First Amendment, and a federal court struck that down immediately, put an injunction on it, and really ridiculed the law and Kwame Raoul's defense of it.
They did quite a bit. And let's take a look at that docket a bit here. And if you look on the federal court's websites for PACER, which is like a service that you have to pay for and whatnot, but you see minute entries. And I want to pull this up because before the preliminary injunction was issued, you had Kwame Raoul attempt to try to file an extension, which we've seen elsewhere as well, right? We've heard this time and again in other cases where the Attorney General's office tries to file an extension for a reply. So they did that on August 3rd, but then the judge immediately, Judge Ian Johnston, said that the motion's meritless on many levels, too many to explain in a minute order. Defendant has been given timely notice of this hearing and was served last week. This lawsuit should not come as a surprise to the defendant. So the judge then was not too happy with them. But then when they had the hearing and they actually proceeded forward, you had a preliminary injunction issued. And in that preliminary injunction, halting the law, it ultimately said that the law was stupid, quote, stupid, and likely unconstitutional as something that could abridge on free speech. Mark Glennon elaborating a bit more on that yesterday when we chatted with him here on WMAY.
Yes, it was totally one-sided. The allegation was that some of the counseling centers were harassing abortion patients as they went into abortion centers. And that would be inappropriate if it's happening. But this bill completely restricted their ability to pass out literature anywhere in the area. And it was one-sided. It said if the pro-choice people, the abortion center, did the same thing, there was no liability there, no exposure. That's called viewpoint discrimination. So that was a clear red line that legislatures cannot pass. And that really irritated the court.
And again, when you look at the docket for this case, you don't see that the state has appealed that preliminary injunction. Asking Governor J.B. Pritzker yesterday, my guy Andrew Hensel got this out of him.
Well, I'm not the one who takes that on. That's the job of the Attorney General, and I do not know. He has not informed me what his plans are for that, but I will say that, as you know, that bill was passed because there are people who work with those crisis pregnancy centers that misinform people. And it's under those circumstances where people are lying, misinforming, in which that law takes effect and people can sue if they're misinformed and given bad information.
But that law is on hold with a preliminary injunction that the governor says he's not informed if they're going to appeal that. Is it politically possible that it'll be appealed?
I think Tommy Raoul will let it die. He doesn't have the guts to appeal it. I wish he would. The Seventh Circuit would then further reaffirm what's going on here. They may try to amend the law. They'd have to really gut it to make it constitutional, or really just let it die. If he just lets it die, it would go to a full trial. I'm sure he wouldn't want that because the judge would just rule the same way that he did preliminarily.
So again, the Attorney General, does he have the guts?
Greg, it's an onslaught.
Mark Glennon touching base with us yesterday. Good to hear some of that conversation, and just want to keep you updated on the latest with that case as well. It is Springfield's Morning News. Follow me anywhere. Bishop On Air. Gmail is the email address, bishoponair@gmail.com. You can also find me on Twitter, Facebook, YouTube, Instagram, all kinds of social media channels. One brand, Bishop On Air. All right.